Hello and welcome. I hope that you are having a fantastic day. Today we're going to talk about Telegram's crypto court clash with the Securities and Exchange Commission. We're going to look at eBay's sale and cryptocurrency, and we're going to look at the United Kingdom court and its crypto ruling. So we're going to have a fantastic program today. Hang on to your hats. Here we go. Our cat Blue has disco fever. Blue wants to dance the night away. Will you help Blue with his dance fever by hitting the subscribe button? Now, I'm not a financial advisor. This is not financial advice. This is my opinion. I'm not smarter than you. You're smarter than you realize. Do not trust what I say. Do your own research. And we're going to provide the links to all of the articles that we're going to discuss today in the comments below. If you don't see them, click the link to view this on the YouTube channel, and you'll find them in the YouTube comments. Also, that gives you an opportunity if you want to dig deeper into the article or to do your own research. So let's get into it. The SEC and Telegram startup are preparing for a cryptocurrency court clash. A startup best known for its popular encrypted messaging application is testing the limits of the U.S. government's crackdown on digital assets, with both sides readying for a court clash in the biggest cryptocurrency case the Securities and Exchange Commission has levied on cryptocurrency. Telegram is feuding with the SEC over its $1.7 billion sale of cryptocurrency in 2018. That's a huge amount of money spent. The agency is accusing Telegram of violating investor protection laws, saying Telegram's digital coin is actually a security and not a currency. The case is playing out in Manhattan Federal Court, also tests an unusual two-part deal structure that Telegram and other companies have used to avoid U.S. oversight. Unlike many of the SEC's target, Telegram had the advice of Wall Street law firm before raising funds, while the investors in its digital coin sale included Silicon Valley venture capital firm Kleiner Perkins, Caulfield & Byers, as well as executives from Fortress Investment Group and SoftBank Investment Group. Now, a major selling factor for the Dubai-based Telegram's cryptocurrency was its founder's record of operating a real business. Telegram Messenger is an encrypted messaging app, has over 200 million active users, including protesters in Hong Kong and, for a time, Islamic State propagandists. Its co-founder, Pavel Durov, earlier stated a social network now known as VK that became a Russian's version of Facebook. The unusual structure invented by lawyers at Cooley LLP and Started Protocol Labs and Inc. was created to avoid regulation, with cryptocurrency sales structured in two phases. That approach separates the receipt of investor funds from the distribution of a digital asset, giving a startup time to develop a product so that it can claim the cryptocurrency has a consumer use and isn't an investment. So what they're doing is investment laws have to do with some sort of an asset, such as a stock certificate, that normally gives you partial ownership in the company. And what this strategy that was developed by the lawyers at Cooley LLP is doing is, instead of it structuring the purchase as an investment, they're trying to structure the purchase as the sale of an application or a actual product. And by it becoming the sale of a product, it doesn't come under the SEC regulations, doesn't come under Securities and Exchange law. And so that's the direction Telegram was attempting to use, and that's the argument that Telegram is going to take to court, whereas the SEC, of course, is going to argue that this was not a product, but rather this was an investment in the company itself. So it'll be interesting to see how this plays out, because the way this plays out in court between Telegram and the SEC will have repercussions of future cryptocurrency development and initial coin offerings and a whole lot of areas that affect cryptocurrency as an industry. Telegram argues the design circumvents SEC override because investors didn't actually receive the digital asset known as grams at the time they sent money to Telegram. By the time they receive grams, if the SEC lawsuit doesn't prevent that, the coin would be a commodity, obviating the SEC's oversight, Telegram says. And so what they're trying to do is structure their activities in a way that what they offer, when they offer a gram, which is something that, that would be their cryptocurrency, it would be called a gram when it actually gets released. But they're trying to structure it in a way that when the grams are released into the public and into the wild, that it is not considered a security, but rather a product. So I think it's a very clever way of going about it. And if my opinion means anything, which it really doesn't in the grand scheme of things, it makes sense to me that the gram is not a partial ownership of the company, but rather an actual product, a cryptocurrency token as a product. So we'll see what the court decides. I don't know that the court will necessarily pick my side of the argument. I don't know if they're going to go with Telegram's argument or the SEC's argument, but time will tell, and we'll know in the near future. In the meantime, ICE, the operator of the Bitcoin exchange Bakkt and the New York Stock Exchange, has made an offer to buy eBAY. So it would be interesting that the company that owns the New York Stock Exchange also owns the Bakkt exchange, may also own eBAY, and this could have some significant ramifications in the cryptocurrency market. The Intercontinental Exchange, operator of the New York Stock Exchange and Bitcoin trading platform Bakkt, has reportedly made an informal offer to buy eBAY, reports the Wall Street Journal. The offer is valued at $30 billion with a big B dollars. The Wall Street Journal reports that this is not the first offer ICE has made to acquire the e-commerce giant. But now that ICE is the owner and operator of Bitcoin futures trading platform Bakkt, which caters to institutional investors and is currently developing a consumer app for Bitcoin, Morgan Creek Digital co-founder Anthony Pompliano suggests a net positive effect having Jeffrey Sprecher, the owner of ICE, operate all three major platforms. So Anthony Pompliano writes, the owner of the New York Stock Exchange is thinking about taking over eBay at a valuation of more than $30 billion. This is the same company that realized the importance of Bitcoin enough to start Bakkt. Would be incredible to combine the New York Stock Exchange, Bakkt, and eBay under one roof. ICE's move into cryptocurrency played out last year with the launch of its new trading platform, Bakkt, which allows institutional investors to gain exposure to Bitcoin through physically settled futures contract. Now, one of the interesting things, so we knew that when Bakkt was going to hit the market and actually became a live exchange September 24 of 2019, that Bakkt was not just going to stop there. And they announced that with their joint venture with Microsoft and Starbucks, that they're developing a consumer app so that you can use Bitcoin to go to Starbucks and buy your coffee or buy a sandwich or buy a pastry, that they had bigger plans. And with Bakkt or ICE owning eBay as well, then you know for sure that they're going to integrate that new application into eBay so that people who are exchanging goods on eBay can do so using Bitcoin via the same app built by Bakkt and Microsoft and Starbucks. And so the more huge vendors such as Starbucks, Microsoft, and eBay that Bakkt gets using their consumer app, the more people that will actually be using and trading in Bitcoin also will affect a whole lot of other things. And so it makes each Bitcoin more and more valuable, and it makes it easier to trade and use Bitcoin for purchases and sales. I also think with the backing of the Intercontinental Exchange, there's a new law that's been proposed in the government, in the United States government, that says that I forget the name of it. I think, if I remember correctly, I think it's called the 2020 Cryptocurrency something or other Act. Anyway, the bottom line for that law that's being debated in Congress right now is that it would allow people to use cryptocurrency to buy and sell goods, as long as when they calculate their capital gains, that the profit on that exchange is less than $200, they don't have to pay any crypto tax. So if that law does get passed, it'll also make it much easier for people to buy and sell goods using cryptocurrency and not have to worry about any kind of capital gains tax consequences. So that could be a significant benefit for Bitcoin and for cryptocurrency being used as a currency or used to buy and sell goods on different things. So the next thing we're going to talk about is DeFi, decentralized finance. One of the companies called MakerDAO, they have a app that you can use to either lend money to people or use to borrow money from the app. They've set things up so that if you're depositing money on the Maker app, you can make somewhere around 8 to 9%, 9 to 10%, 7.75 to 8.75% annual income, annual percentage rate by depositing money into the MakerDAO application. And so if you're interested in taking your cryptocurrency investment and earning an annual interest, this is something that you might want to consider. Finally, in the English court in the United Kingdom, the English court confirms cryptocurrencies as crypto assets as a property. And one of the reasons why I want to bring this up is because by saying that cryptocurrency is a property, it has implication when it comes to income tax, implication when it comes to theft, implications when it comes to insurance, and a whole lot of other things. And while the United Kingdom may not be where you live, the decisions that the courts make in the United Kingdom can affect the court decisions in your country. And so the English court has now made a clear ruling. I consider that crypto assets such as Bitcoin are property. Brian J. concludes in his judgment. Unlike the previous cases, which only act as persuasive authority on the matter, such as the one on our previous blog post, the court here fully considered the issue of whether cryptocurrency is a property and made a direct ruling on it. The judgment ratifies in English law the UK Jurisdictional Task Force statement on the subject published in November 2019, which otherwise has no formal status as a legal precedent of its own. So the finding that cryptocurrencies are property under English law will have a significant consequence for the application of a number of English legal rules, including those relating to the succession of death, the vesting of property in personal bankruptcy, and the rights of liquidators in corporate insolvency, as well as cases of fraud, theft, or breach of trust. And so this is significant in the cryptocurrency industry because it affects such a wide area of law when it comes to cryptocurrency, as well as it could have implications in other countries, not just the United Kingdom. And so based on the way the U.S. courts tends to rule things, I think that'll have an implication in U.S. courts, and I think it'll have an implication on courts all over the world. But again, this is just my opinion. That and 50 cents, well, that's not even going to buy coffee anymore. So that goes by the wayside. Anyway, how can I be of service to you? Do you have questions on anything that we covered today? Is there anything outside of what we talked about that maybe you want me to talk to you about, dig in deeper? I'd love to hear from you. In addition, if you have a disagreement with what we said, please leave your comments below. I'd love to hear your polite disagreements because I know you know things I don't know. I know things you don't know. And when we share what each other what each other knows, we will learn together, we will grow together, and I want to get smarter together with you. So in the meantime, like, subscribe, and hodl, and I hope that you have a fantastic